I think we're going to get started. Welcome to Blue Cities, Red States, the troubling turn in state preemption. That's the panel. If you're here for a different one, it's not too late to leave. I'm Nestor Davidson. I'm a professor at Fordham Law School, and I'll be our moderator today. And before I introduce our panelists and talk a little bit about our panel, I have some quick notes. So first, please turn off all your cell phones or put them on silent because we're taping this. If you're tweeting about the session or the national convention, ACS's Twitter handle is @ACS Law, and the 2018 National Convention's official hashtag is #ACS 2018. I expect to see a steady stream of tweets out of this session today. If you're getting CLE, make sure you scan your barcode at the beginning by one of the ACS volunteers, and if you sneak out early, in case we're boring, you have to scan out on the way out. And CLE materials can be found on the ACS Convention webpage, and a link is provided in the convention program. And finally, we have a microphone when we get to the Q&A, because we want this to be an interactive session. Please come up to the mic, and that way we can make sure you're all recorded. Okay, with those public service announcements, let's get into this. We're going to be talking today about a sort of new world of state and local preemption, and we're going to tie it later a little bit to some dynamics in the federal, state, and federal local. But we're really focused on, as the title of the panel suggests, conflicts between primarily cities and states. And we've seen really over the last 7-8 years a sea change in state preemption. Preemption has become much more ubiquitous, much more targeted, frankly much more punitive than it once was. It's always been a tool in state-local relations, but it's become much, much sharper. We'll hear about a lot of those dimensions, and it's really generating a very interesting jurisprudence as cities are fighting back and courts are having to grapple with this new dynamic. So there's a lot of really interesting things happening on the ground. And to explain these dynamics and to engage in a conversation about this, we're delighted to have with us, and I'll just introduce our panel very quickly from my left, the Honorable John Russell, the Director of the American City County Exchange and a councilman from the town of Culpeper, Virginia. Ala T. Johnson, the Jerome B. Sherman Professor of Law at Columbia Law School. Ames Simmons, the Director of Transgender Policy with Equality, North Carolina. And finally, Adam Skaggs, the Chief Counsel for the Giffords Law Center to Prevent Gun Violence. And with that, let's begin with John.
Great, thank you for the opportunity. As I was thinking about being with you today, I was wondering, well, what can I bring to a room full of young and also mature, progressive legal minds? And what is it that you need to hear, and what's kind of going on in the ground across the country? My work, I'm very fortunate in my work that I'm able to travel and go to a lot of different states and different cities and counties and kind of get a pulse on what's going on, both in red and blue states. One of the things that struck me through this whole course, I've been tracking and mapping state preemption for the last 5 years on a serious level, but historically, even going back, you can look 20 to 30 years ago, how state preemption started coming to the surface in regards to the smoking bans. Actually, during the smoking ban eras, what happened were counties and cities were actually starting to band together and saying, yeah, well, we're not going to allow smoking inside of establishments, and then eventually put upward pressure on the states to move and do a statewide smoking ban. That's probably more contemporary in regards to where this discussion's going today. I've come to the point, though, as an elected official and both working in this area, that I really believe that the struggle between state preemption and local control is not at all an issue or a paradigm that benefits my constituents. At the end of the day, what I'm looking to do is to work with my state reps or my state senators to be able to achieve and to get things done for my community. Now, as an elected official, I take an oath to the Constitution. I take an oath, and what that means to me is that I work to protect individual liberties of my constituents. I also work to uphold equal justice before the law. Those are my two primary tenets as a local official, or any elected official. And so when I'm looking at the issues of state preemption and local control, I'm looking at it issue by issue. what exactly is benefiting my constituents? How is it promoting liberty for my individual constituents? How is it upholding the law or equal justice before the law? And whoever provides that for my constituents, that's what I'm for. So if that's the state bringing that to my constituents, I'm for that. If that means local government does it, I'm for that. If it means the federal government does it, I'm for that. Because that's what drives me and motivates me as a lawmaker, is to make sure that my constituents are able to run their small businesses without punitive taxation and over-regulation. Okay, are my individuals able to use their property in the way that they want to use it, or are they being told that they have to do it a certain way by the state or local government? At the end of the day, again, it's issue by issue. There is something troubling, and it's both sides, both left and right. There tends to be a lot of hypocrisy and a lot of, how would you say it, disingenuousness of the issue when it comes to state preemption. Because what you'll have certain states like California, or I'm sorry, let's use Oregon, that's a better example. So Oregon passes a minimum wage increase. It's a 3-tier increase based on the jurisdiction in which you live. There was no talk of local control. Hey, this is my control. But whenever the state preempts local governments and says, no, we're not going to raise minimum wage and you're not allowed to either, then it becomes, oh, well, we're about local control. You didn't have that same argument in Oregon, and it's the same people fighting for that same issue, just in a different state. So you have to watch how it becomes disingenuous. Now, the issues are very real. Yeah, all these issues that everyone here at this table, these are very real issues. But we have to be careful that we don't fall into this trap of we're saying, well, you know, I want local control unless the state does it, and then I don't want local control. You can't, that's holding two sides of an issue. You have to understand what is it that you believe and what is it that you're trying to achieve. If you're trying to achieve doing local control and allowing local jurisdictions to pass certain things to create that upward pressure on the state, that's fine. But don't fly the banner of local control on that. If you're wanting to do state preemption, okay, don't come around on another issue and say, well, I believe in local control. Because it is issue by issue, but I'll give you a good example of that. You know, we're looking at education, okay? So education is one issue. And you hear Republicans in particular say, oh, we believe in local control of education. And then in other states, they'll go and they'll try to preempt local school boards from doing certain things. And there doesn't seem to be a consistency in the way that they proceed in those laws. And so I've kind of stepped out of that and have just said, listen, I want to work with everyone to achieve maximum liberty, maximum justice for my constituents. And I don't care who gives it to me, just give it. So I want to challenge you to kind of think about this differently. There needs to be an honest discussion about state preemption and local control, which is superior. I mean, let's be quite honest. Local elected officials don't necessarily all have halos, okay? And they're not perfect in the way that they legislate. And they don't really necessarily always have the ear to the ground. A lot of times it's the pocketbooks of the bigger contractor or developer in the community. So there's always this, politicians are politicians. And so as you proceed and kind of thinking through this issue and working through it, I always tell people, if you don't like the way the state's doing it, then change the state, change the election, change the people that you want in that position if you want to move a certain issue. But don't make disingenuous claims that local control is far superior until you get the guys you want in the state house, and all of a sudden you forget about local control. Thank you.
Thank you, John.
Okay. So thank you, Nestor, and thank you, ACS, for inviting me. So I think John raises a number of interesting issues that I hope we return to, that have to do with the question of whether we care in itself about the levels of government at which policy is made, whether there's something superior about things being done at the local level or whether it's just strategic. I just thought in my few minutes of introduction before we get to more of the interaction between us as panelists that I would talk a little bit about what I see as some of the big kind of political trends that are driving preemption, at least state preemption of what we might call progressive localism, and then just highlight some of the kind of potential legal pathways. And then I don't think we'll have full time to talk about this in the first round, but just sort of to return to some of these issues about where we want policy to be made and why it should be made in a particular area or not. So I think what motivated this panel was thinking a lot about red states and blue cities, that phenomenon of state preemption of a lot of progressive local policies. And I think groups that, I'll just use the shorthand of progressive, have invested a lot in advancing progressive local policy in a number of different areas at the city level. And you really have seen a reaction to that through a tactic of state preemption of this kind of progressive localism. It's not just taking place actually in just red states, but I think some of the more punitive versions of it or the broader versions of it are concentrated in red states, and perhaps I think empirically the phenomenon is greater in red states. So I think in some ways it's a reaction to the success of a lot of the progressive policies at the local level. And it's around, talked about healthcare, smoking, immigration, so-called sanctuaries, labor, minimum wage, parental leave. And you see huge increase in cities regulating in these areas in response to social movements, and that has been kind of a success that a lot of progressive groups have touted. And so I think you're seeing this as a kind of reaction to that. Some of those political dynamics that influence progressive groups being invested in the strategy of localism in the first place, I think some may have reflected a kind of commitment to localism, which we can talk about. I think a lot of it has just been pragmatic, and it's not unusual, right? A lot of progressive policy in this country around wage, I work a lot in the civil rights area, started on the local level, and there's a theory by which that's a good thing, right? I mean, we have a whole theory of American democracy that's based on experimentation at the subnational level. And you could see that moving from states, from city to city, and then eventually perhaps moving up to the national level government if it's appropriate. And so I think the reaction to that has been that well-organized groups who are opposed to these kinds of reforms have mobilized at the state level to either preempt cities from enacting that particular piece of regulation, for example, in the minimum wage area or around sort of sexual orientation, gender identity expansions, or have enacted more broader kind of preemptions or punitive preemptions. And so these are industry-supported groups also like the National Rifle Association that we'll hear more about, and of course the American Legislative Exchange Committee, ALEC, which has been very effective, I think, in really creating networks by which a lot of these preemption bills are moved from state to state in a quite an organized way. And sometimes you see the identical language moving from state to state, even though that it doesn't really reflect anything particular about that state. So I think that when we talk about what's fueling preemption, I do think that there are some these larger kind of political and demographic trends that I think most of us know well, right? Which is that you can be in a so-called red state, but it does have, metro areas might be expanding. They might be places that are ideologically disharmonious from the rest of the state, to put it mildly, where people who are progressive cluster. I mean, and this is happening throughout the country. I think it's also made possible, though, by a kind of an intense partisan polarization. One that I think is fueled by interest group activity, by money. Nestor Davidson and Paul Diller actually have done some interesting work that I hope you talk about the ways in which those states that engaged in a lot of partisan gerrymandering are states where there is more of this preemption happening. So I do think that we should connect it to some of these democratic breakdowns, including gridlock at the federal level, and think about it in that context. And in the spirit of thinking about, what ultimately, because I think we should return to this, or the solutions to this beyond litigation, I think as we think about what we want our democracy to look like, we want to think about how much of this reflects a kind of healthy disagreement, variation, lack of consensus around key issues, and how much of this is actually something darker. I've spent time talking to groups. For example, I was talking to a group in Fayetteville, Arkansas. It was actually city officials who had expanded their anti-discrimination ordinance to include sexual orientation, and really saw themselves being preempted. They were preempted by the state. And they're, in having conversations with them, they just said something different has happened in our political environment. In which that makes dialogue not possible between states and cities, where they felt that there was a lot of, C described it, dark money coming in. And we know some of the trends that have, people who have documented this happening at the state level, the greater investment by conservative groups, for instance, on state legislatures than their counterparts on the progressive side. But it was just interesting to hear someone talk about it just from a real lived experience of really seeing kind of a change in the tone and the dialogue. So I think we have to assess how much of this is about breakdown and how much of it isn't. So I just a couple more things, and then I just move on to someone else. I think that we will talk about hopefully more what are the legal challenges that one can bring. I think it's not actually, when a state preempts a local ordinance, it's not an easy landscape to figure out exactly what kinds of challenges you can bring if you don't have a situation where localities have a lot of authority granted to them by the state constitution. And so one of the things that I've looked at a lot, because I've spent some time thinking about wage ordinances and anti-discrimination preemption, or the ways in which you can use federal law. And there's some interesting challenges bubbling up on that front. For example, in Birmingham, they raised their minimum wage. Some of you may know this. They raised their minimum wage, and the state of Alabama almost immediately, there's no statewide minimum wage, but said that you cannot do that at the local level. And that's being litigated actually under a voting rights theory, because it's a majority-minority city. And different kinds of theories about the ways, who are the main beneficiaries of that minimum wage increase. So a lot of southern cities who are seeing preemption, if you look at the map, a lot of it is concentrated in the South, and is in cities where there's a fair amount of minority control, people of color in control at the city level, and see themselves preempted in a kind of dynamic that they think is highly racialized. And so it's very interesting to think about the voting rights openings there. The other is that sometimes, and I hope Ames will talk more about this, but sometimes when you preempt something at the state preempts civil rights oriented kind of legislation, it conflicts with federal law. It can conflict with Title IX on gender, and it can conflict with the Fair Housing Act. And so we see examples of being able to, or at least openings to challenge things as conflicting with federal law. And then finally, I think that there's some interesting ways to think about using whether or not there's some equal protection limits to the ability just generally to preempt, particularly around minimum wage and civil rights, that are derived out of the fact that some of it reads like invidious discrimination. It feels like it's motivated by a kind of animus and intent. These are not easy things to prove. One of the things you see in the sexual orientation, gender identity preemption area is that this generation of preemption is not like Romer. You remember Romer, where they actually said you cannot do this around sexual orientation. These are not explicitly saying that. They just say you cannot have any anti-discrimination protection at the local level that you don't have at the state level, but the only category it applies to sometimes is sexual orientation and gender identity. And so it's harder to show invidiousness, but on the other hand, on the face, but on the other hand, sometimes there's no other reason that one can think of for not allowing localities to determine issues around sexual orientation and gender identity at the local level. There's a long history of regulating these kinds of things at the local level without generating externalities, as law and econ people like to say. And it's not. There's nothing on the record, on the legislative record, showing harm. So I think there are openings for using that and for using a kind of half-alive theory of political process, which also links a little bit to Romer, that comes from these cases that we can talk about more, that limit the ability of states to enact burdens on localities when it's burdening a particular, the political expression of minority groups in particular. It may be that just applies to race. It may not apply to sexual orientation, but also provides an opening. So the last thing I'll just say is that I think I am someone who actually comes at this from the civil rights perspective. I'm not really a state and local person by training. I got into this because I was writing about all of these innovations that were happening at the local level, and that I thought were really promising, and this was 3 or 4 years ago, and then it turned into, and there are, half of them are being preempted if they're not happening in states that are not amenable to them. And so, so when I think about the ideal local level of government, for a lot of civil rights legislation, it actually is at the national level. That's where you want it made. If you really believe that people should not be discriminated against based on an identity characteristic, for instance, that should be done at a national level. It should be a right of citizenship that adheres to everyone. And I don't think there's much justification for just saying it happens locally. So that's why I think this is mostly pragmatic. But I think it's an important kind of pragmatism, because I do think that you build consensus for things by building the appetite at the local level for thinking it's okay, that we can survive with gender identity and sexual orientation, anti-discrimination laws, and it won't be the end of that. Minimum wage, I think, poses a more challenging issue, because I think there are questions. I don't think that Birmingham's minimum wage is right for the rest of Alabama, for instance. It may not be, right? And I think there are real questions about who should decide where wage policy is set, even if there's variation. In New York, we raised our minimum wage, but had variation among rural areas and city areas. So maybe that policy should be made at the state level. But again, there's not much on the record really supporting these. They're not sophisticated theories. They usually, there's not much discussion of this. And I think ideally, if we have the kind of healthy discussion John is talking about, maybe we would be further along in having a real discussion that wasn't just motivated by a kind of a set of interest group politics.
Thank you.
So holding down the interest group politics perspective. Thank you for having me, Nestor.
Not a bad thing necessarily.
My name is Ames Simmons. My pronouns are he and him in English and él en español. And I'm Director of Trans Policy at Equality North Carolina. So just so we're all on the same page, Equality North Carolina is a nonprofit that works to secure justice and equality for lesbian, gay, bisexual, transgender, and queer North Carolinians. I'm an attorney barred in Georgia, and I'm seeking comedy in North Carolina, and it's a process. And I'm also a queer transgender man. So when I arrived in North Carolina in January of 2017, the law that we commonly refer to as HB2 was still on the books. So I want to talk a little bit about the history of HB2, particularly from a preemption perspective. So at that time, Pat McCrory was governor of North Carolina, a Republican, and then and now currently our state legislature, the North Carolina General Assembly, the NCGA, is controlled by supermajorities of the GOP. So what touched all this off was the city of Charlotte passing a non-discrimination ordinance that, among other things, forbid discrimination on the basis of sexual orientation, gender identity, parental status, or familial status in contracting and public accommodations. And it also deleted language that had been part of the ordinance that carved out restrooms from the sex discrimination provision. So if you can follow all that double negative, it basically terrified people by saying trans people could, be in restrooms. And so this led to this public campaign about Charlotte values to invoke what Alati was talking about as far as blue cities and red states, although I don't think that non-discrimination is by any stretch only a blue city value. So in retaliation to Charlotte passing this, so Charlotte passed this law in February. The legislature was not supposed to convene again until the end of May because it was short session year. And so they convened a special session 8 days before Charlotte's law was supposed to go into effect. So this is $42,000 a day for them to have a special session. And in 12 hours, they passed the Public Facilities Security and Privacy Act, which, among many other things, required that everyone, including trans people, use those public restrooms that are in accordance with the gender listed on your birth certificate. HB 2 also included this section called the Wage and Hour Act for the stated purpose of, quote, statewide consistency in laws related to employment and contracting. And I think that's important. That's a theme that constantly came up as we were talking about repealing HB 2, was this need for there to be consistency for people traveling across North Carolina, that people from rural North Carolina might be suddenly thrown into chaos in urban restrooms if they came into contact with trans people. So this, I won't go into a lot of detail, but this portion of HB 2 had all kinds of human resource kind of law preemption, so no local regulation of minimum wage, maximum hours, minimum age, or paid leave benefits for workers. A third provision of HB 2 preempted any local regulation of discrimination in employment and also removed a private right of action in employment discrimination. So there was immediate outrage from the plaintiff's bar. And within just a couple of weeks, Governor McCrory issued an executive order that basically restored the private right of action and ordered non-discrimination for state employees while leaving the rest of HB 2 intact. So over the next year, HB 2 got a lot of conversation in North Carolina. A lot of it outside of our state revolved around this kind of non-fact-based fear that trans people were putting this privacy and security of particularly women and children in danger in restrooms. And in the meantime, within North Carolina, a lot of the dialogue revolved around the economic cost of this law to our state, as we lost PayPal did not come to North Carolina. There were jobs that were lost because of boycotts. My organization, Equality NC, didn't advocate for those boycotts because we know that they also hurt LGBTQ people in our state and their families. But nevertheless, there was a lot of dialogue, particularly about basketball. And as a trans person in the state, to constantly be asked about the cost of the NBA games being moved or the NCAA being moved out of the state, I tried to constantly be lifting up that there is a human cost to this. Like, this is actually affecting actual trans people who end up restricting what we eat and drink so that we don't have to use public restrooms, and that has real life health effects. Even less of this talk revolved around the politics that were behind this preemption. What I thought amounted to our state legislature's really cynical power grab of cities' abilities to protect their residents from real harms like anti-LGBTQ discrimination and wage theft. So none of the repeal compromises that were put forward actually cleanly repealed the preemption. There were various proposals that included requiring local ordinances, like they would be okay, but they would have to be petitioned to a ballot that would have like a really high, unreasonably high percentage of voters that would have to vote for it. Or we would kind of put back in all the anti-discrimination protections except for sexual orientation and gender identity, or that we would have a cooling off period where no new ordinances could be passed. And ultimately, the replacement for HB2 ended up with that. A combination of a very long sunset for ordinances that protect residents in private employment or public accommodations until December 2020, which is the month after, of course, the next presidential election. And it permanently restricted cities' ability to protect their transgender residents in restrooms by preempting any regulation of restrooms or changing facilities, which is language that was so vague that almost no one has been able to successfully interpret it, and has caused a great amount of confusion among school districts who don't know what they're supposed to do, how they can best accommodate a student who comes out as trans and asks to use the facilities that are consistent with their gender identity. I want to lift up a report by the Movement Advancement Project that just recently came out about preemption. The Movement Advancement Project is an organization that works on messaging LGBTQ rights on a broader level. And preemption, I think, is a hard topic to sort of get the general public to understand and be sympathetic toward. And particularly, I want to point out the name of the report, The Power of State Preemption, Preventing Progress and Threatening Equality. We can talk some more. I hope that we'll have some more discussion later on about other types of preemption. We have definitely seen preemption in North Carolina on a very wide range of topics, but the one that has most come up for us in the LGBTQ community is standing against preemption of immigrants' rights in North Carolina. Sanctuary cities are already preempted, and we did see legislation in the last session that would preempt alternative forms of ID that they're called faith IDs because of the nonprofit that has been successful in getting some municipalities to honor them. These are good not just for people who are undocumented, but also for trans people who have a lot of difficulty accessing ID in North Carolina. So I think there's a natural opportunity for coalition work here that I think is a way forward, and I look forward to talking about it more. Thank you.
Thank you so much.
Thanks. Well, I think Ames has shared a powerful sort of case study of an issue related to preemption that, in his words, have real life health effects. And I'm going to share another case study that I would argue also has had and continues to have real life health effects, and that's preemption around firearms. My case study is going to be a little bit different because it's going to be more of a national look at what states have done on this issue with firearms preemption laws. Before I do that, and I'll share this case study, and then I am eager to engage with the panel and engage with audience questions as well, because I think some of these overarching issues are really, certainly apply beyond any particular subject like guns, and I think are where some of the most interesting parts of this conversation will be. I think I would agree with at least what two of the other speakers have said, which is that I don't think there's any way to generalize that local control is always better, state control is always better, federal control is always the solution. I think issue by issue and case by case solutions make sense. And I think, we've heard John shared the idea that he comes to a value judgment about which level of government makes sense based on the commitment to liberty, to freedom, and that value. And I think depending on sort of the animating value that is motivating the judgments that you make, if it's equality in the case of the report, you may think that certain policies should be made at a different level of government. But depending on the animating principle, whether it's equal dignity, whether it's equality, whether it's equal opportunity, whether it's liberty or freedom, if those animating principles are driving your decision about which level of government makes sense, I think you can make a reasoned, consistent decision in each case without always deciding local control beats state control or federal control is the best of all. It's just about really what the animating values are that are making your decisions about what level of government should have control. And I think we should be careful when we start talking about accusing somebody who reaches a different decision than you on one of those decisions of being hypocritical or of being disingenuous about their commitment to government, and take a close look to see whether the disagreement that would lead us to bring a charge of hypocrisy is in fact a disagreement with the animating principle, the values that have animated somebody else's decision. So I think that's something we should think about. And turning now to guns, guns is certainly an issue where I think some decisions are made best on the local level. And I'll tell you this case study of how the ability to make decisions at the local level have been stripped away from most municipalities around the country. But there are certainly decisions that I think are best made at a federal level. And I don't think there has to be tension between thinking some decisions are best made locally and some at the state or federal level if, in fact, the animating principle in my case, what drives my animating principle when it comes to guns is the notion that we should all live in safe communities. We should all live in communities without the fear of gun violence ending our lives or those in our families or those in our communities. And so that depending on the types of questions, I don't think all decisions on guns or any other subject should be made at one particular level of government. I think we should look at the type of gun policy we're talking about and figure out if our animating principle here is the idea that we want all people to live safe from fear, all people to have the right to live without being shot, then a particular type of regulation, let's with that animating principle decide what level of government should make the decision. So with that sort of initial thought, let me just share a story about preemption and guns, and I think this is similar to preemption efforts that we've seen on other subjects, but not necessarily identical to all of them, but in some ways sort of a paradigmatic example of how states have stripped away local control over certain issues to, in my mind at least, often very unfortunate effects. So we're going to sort of wind the clock back to start this story to 1981. And in 1981, in response to sort of growing crime, and in particular crime involving the use of cheap, poorly manufactured handguns, often called Saturday night specials, a town in Illinois decided they were going to ban handguns. So the town of Morton Grove, Illinois, in 1981 issued a handgun ban, making illegal the possession or use, carrying of handguns within city limits. Let's leave aside whether that was a good policy or not, whether that policy would actually keep people safer or not. Let's leave aside the policy debate and just suggest that that was a response that that city wanted to try. The gun industry was not happy about this. This began to spread to other communities as well. The gun industry obviously saw a potential existential threat to its bottom line. Gun lobby organizations, gun industry affiliated groups like the National Rifle Association thought this was a very bad idea, probably for a variety of reasons. So they did what many of us would do as lawyers. They sued. They saw a law they thought was a bad idea or dangerous. They sued. Unfortunately for the NRA, they lost. They sued in federal court. They sued in state court. In 1984, the Illinois Supreme Court rejected the constitutional challenge. So they said, we're afraid this law is going to spread to other cities. This is bad for a variety of reasons, I'm sure they thought. So what can we do? We can't, these can't be held unconstitutional. This, of course, was many years before the Heller decision that would have come to the conclusion that it was, in fact, unconstitutional. What they did, having failed to have these laws struck down as unconstitutional, was they embarked on a campaign of preemption. So I said, in 1981 was the year that Morton Grove passed this law. In 1981, there were only 3 states, either by state legislation or by judicial decisions that had been rendered. There were only 3 states in the country that had firearm preemption of any type, 3 out of 50 in 1981. The NRA began the campaign. By 1991, just a decade later, more than 41 different states had these broad, sweeping firearm preemption laws. So basically, the NRA saw a threat to their priorities and rolled out a concentrated effort to get 41 state legislatures to pass laws that said local government, city officials may not regulate depending on the language in the statutes, the manufacture, the sale, the possession, the licensing, carrying, et cetera, of firearms. So essentially they said the only regulations for guns that are going to be passed in these 41 states is going to be in the state legislature, where they had a certain sway, and they're not going to be made at a city-by-city level. Illinois, perhaps ironically enough, was one of the states that held out, and they didn't actually get any kind of firearm preemption laws in Illinois until 2013, just a few years ago, and that was in response to Seventh Circuit decision that made Illinois be the last of all the 50 states to legalize concealed carrying of handguns in public. And at that point that they were compelled to do that, they decided to adopt sort of a statewide regime for regulating concealed carry. So Illinois is sort of the most recent state to adopt any kind of firearm preemption. And depending on how you classify Illinois, which is sort of partially preempts what localities can do, we now have 42 or 43 states, again, depending on how you count, that broadly restrict localities from regulating guns. This is sort of where the next part of my story happens, which is around the same time, as I said in 2013, that Illinois decided to legalize concealed carry and partially regulate that in a preemptive way at the state level. Well, 20 years after this sort of first wave of NRA-backed preemption laws had passed, so fast forwarding now to 2011, right around the same time that Illinois became one of the last preemption states. NRA-backed lobbyists, NRA-backed legislators, I think had just not done much on preemption with guns for 20 years, and they thought, well, let's do more. Let's preempt even further. The stated justification for this was that in spite of these preemption laws on the books that rendered null and void any local regulations, there were some recalcitrant sort of holdout city officials that still wanted to try and do something about gun violence in their cities, and that had to be stopped. These upstart local officials, of course, dealing with patterns and levels of gun violence very different than in other parts of the state, we're trying to figure out, well, in spite of preemption, what are the areas that are not preempted? What can we do? Trying to do something there on the front lines of the fight against gun violence. And so apparently legislators in a number of states thought, this is something we have to stop, this scourge of local attempts to reduce deaths from gunfire. So they thought, well, what we can do is we can do one better. We can put some real punitive provisions in these preemption laws. So it's been referred to alternatively as super preemption or preemption on steroids or punitive preemption, whatever you want to call it. What happened beginning around 2011 in Florida was that in a smaller number, not all 43 states, but in a smaller number of states, legislatures went back and just really upped the ante, so to speak. And they began including punitive provisions that included things like any city official, either who passed an ordinance dealing with guns that arguably violated preemption, might be subject to civil fines, onerous civil penalties, might be subject in cases like states like Florida to removal from office if they did anything about guns. In some cases, they were explicitly prohibited from using any local public funding for a city to defend itself, so officials would have to defend a lawsuit themselves. One state, Kentucky, even went so far to say that if you violated, not just if you violated the state preemption law, but if you went so far as to violate the spirit of the state preemption law, you'd be subject to criminal penalties. So that really took it to the next level for local officials. And then to make sure that this new strengthened preemption type of regime would have the teeth that it was intended to have, in a number of states they said, and to enforce this, anybody who's negatively impacted by, anybody who's harmed by one of these existing city laws has standing to come to court to sue, even if the city immediately rescinds the ordinance. Let's say they'd had a prohibition on firing guns in city parks on the books for 50 years. Even if they said, oh, well, okay, we haven't enforced that, but we'll immediately rescind this statute, they would have to pay the attorney's fees for the gun lobby lawyers who sued them about it. Some states had formulas like if you sue and they immediately rescind the ordinance, they'll have to pay your attorney's fees. But if they choose to defend the case, if they actually litigate it and lose, and it's declared that that was preempted, they'll have to pay, treble damages in effect. They'll have to pay 3 times the attorney's fees for the gun lobby groups. So this was sort of like a, gun lawyer full employment act that they were just sort of dangling the bait out to gun lobby lawyers. And if that didn't make it easy enough, Pennsylvania, one of my favorite examples, Pennsylvania passed a law that said any individual or group who is adversely impacted by the existence of a state gun law has standing to go into court and sue. Well, okay, so adversely impacted, you think kind of Article 3 standing. Well, then in the same statute, they went and they defined what it meant to be adversely affected by the local ordinance. And the way they defined that was to say, if you can legally own a gun anywhere in the Commonwealth of Pennsylvania, you're adversely affected. So this might be a Philadelphia ordinance on the books. You might live in Pittsburgh. You may have never been to Philadelphia, but if you could legally own a gun in Pennsylvania, you could sue Philadelphia. In Pennsylvania, you could sue Philadelphia. You could get your lawyer's fees, and at the end of the day, maybe you get 3 times your lawyer's fees. So, thankfully, from my perspective at least, thankfully this wave of very punitive preemption laws has not spread as widely, but it has. But these types of laws have been adopted in half dozen states or so. Florida, as I said, sort of started this trend. Kentucky included the criminal penalties, and a number of other states, Arizona, Mississippi, some other states that have similar laws. These have provoked dissatisfaction, I'll say, with some local officials who think they're overreaching. And so what we've seen in a couple of cases, and most recently in Florida after the Parkland shooting, which has sort of created this whole level of energy to do something about gun policy, and that's in the Sunshine State, what we've seen is now 3 lawsuits that have been filed in recent months. One on behalf of 20 different cities and local officials, another one on behalf of a smaller number of cities and local officials, the third on behalf of Broward County, of course, the county in which Parkland is located and the shooting occurred. All of those different lawsuits have challenged not the basic bedrock notion of preemption, but have just gone after these punitive provisions. And those cases are sort of moving quite slowly. They've just all been consolidated or in the process of being consolidated. So they haven't gotten very far. But I think the types of claims, and I'm not going to go through all of them because there are literally dozens between all the lawsuits of different but similar claims. But just to paint a picture of sort of some of the types of theories that are being asserted, I think will be helpful, and it'll give us an opportunity to think about it in the context of some of the other types of preemption laws that we'll talk about today. On the most basic level, states that have strong home rule provisions in their constitutions are going to give cities an opportunity to challenge not just the punitive parts of preemption, but preemption as a whole. And in some cases, Colorado notably, cities have sort of carved out a particular ability to regulate on guns on like particular matters of local concern, even though otherwise state preemption still exists. So you've got state constitutional home rule provisions, and then you've got a range of different federal constitutional arguments, the basic principles of legislative immunity, which I suppose are both in the speech and debate clause in the federal constitution, as well as protected either by common law, by judicial decision, or in some cases state constitutional provisions. The principles of legislative immunity that would allow local officials to say, if our actions are found to be preempted, maybe they're not enforceable, but you can't then sue me in my individual capacity and require me based on a legislative act that I did to pay some onerous fines. There are some separation of powers arguments that are being brought, particularly with things like removal from office, where the legislature has said any official who does X, Y, or Z should be removed from office, and the state constitution says the only person who can, or the only office that can remove somebody else from office is the governor, so there's some separation of powers issues. There are basic governmental immunity principles that have been invoked in some of these cases. And then there are things like due process claims, both with respect to due process claims of a property right in the office that I'm holding and should not be removed from without an appropriate process, due process vagueness arguments when you get to statutes that provide penalties for doing something like violating the spirit of a preemption law. And then fundamentally, there are First Amendment claims. Some of the lawsuits that gun lobby groups have filed under state preemption laws have asserted claims saying if the city council members do not all come in and vote to rescind an old ordinance that's been on the books for 30 years, then the city's on the hook, then they're on the hook for civil fines and so forth. And commissioners have refused to cast those votes and then argued that any attempt to force them to act would violate First Amendment principles. So I think exactly how these lawsuits are resolved with respect to some of these punitive provisions is at this point still an open question. But I think this current sort of battle, this current sort of front in the battle about local control and preemption, at least when it comes to guns, is going to be an interesting story to watch, to see if courts are willing to step in and say, look, we can disagree about policy on certain levels and the level of government policy decisions should be made, but in at least some of these cases, I certainly hope the courts will say, this has just gone too far, though. This has gone beyond the pale in this attempt to chill legislators from taking actions to keep their communities safe. And I guess my hope is that the courts will step in and at least set some outer limits to the type of political decisions that can be made on these, which I guess gets back ultimately to some of the fundamental questions about sort of our democracy and how we want it to function. So that I guess I'll rest there.
Great, thank you so much. What a rich set of opening comments, and it's sort of hard to know where to begin, but I do think it's useful to, one theme through all of these, and I think it's worth amplifying a little bit, is this question of the interplay between given issues and how we think about questions of allocation of power. I do, Adam, I'm really drawn to your description of trying to focus on issues and try and derive structural principles from a given conflict, a given issue, and John, that echoes a little bit with what you were saying. But I think part of the challenge is as cases are playing out, I think that the ground of so much litigation, not necessarily in the kind of Equal Protection or Voting Rights Act kind of context where you're really litigating on grounds about, for example, equality or other constitutional rights or liberty. But so many of these cases, like the current round of Florida cases, are really fundamentally about what level of government should decide and how the process of democracy should play. So on any side of these issues, I really want to hear more about pragmatically and strategically, how do you balance that? Because, sort of at an abstract theoretical level, you can think about pragmatism, you can think about, the sort of basic landscape of policies. I mean, right now, just given kind of the landscape, if you care about equality, cities may be the best hope, just pragmatically, right? Just sort of where policymaking they are and where people live. But in individual cases, you still have to then discern principles that you can bring to court that courts can then decide that will live on beyond that litigation. And so I'm just curious to hear a little bit more from everyone on the panel about how you balance that sort of pragmatic argument in individual cases and a larger question. John, you want to start?
Yeah. So the case that's most referenced in support of preemption is Hunter versus Pittsburgh. It really is the catalyst for state control over their creations, which are local governments. That's why you're going to be very hard-pressed to find any lawsuits where localities have been successful at challenging preemption. This set the tone, this lawsuit here, just to give you some context, basically what it was is that the state of Pennsylvania had created a law saying that any jurisdictions which were next to each other in proximity could vote to annex the other. And so as a result, Pittsburgh ended up annexing Allegheny. Allegheny disappeared and became part of Pittsburgh. People of Allegheny said, this isn't right, so they sued. So what ended up happening was the state came back, Judge Dillon came back and said, this is the state's prerogative. They created you, they can dissolve you if they wish. And so I think what he was talking about going after the punitive, I think that there's a lot of merit to that. because no state should go after local governments to determine what they can say and what they can do in regards to, if my council wants to pass a resolution opposing a state bill that was passed or a law that's in existence, to stop me from doing that would be silencing my constituents. It would be silencing my First Amendment right. So I think that there's a lot of merit to going after state preemption in that regard. But my opinion, just having worked and researched in this issue, going after the state preemption as you don't have the right to preempt me is a loser. That's what the states are. The states were the creators of the cities and counties. And if they decide to do something, then that's what the cities and counties have to go for. But if they do the overreach in regards like the punitive, yes, there are different recourses. So that's just my opinion on that.
Great.
Yeah. So, I mean, I think you've asked a hard question in this area. I guess I would say pragmatically, I have different ways of thinking about this. I've worked with groups that are working on a lot of these different issues around immigration preemption, labor, civil rights, and even gun preemption. And I do think about them differently, but because I have a policy in my advocacy hat, I mean, I have a policy-based interest in advancing all of the things that are happening at the local level. So I'm very much any lawyer in the room who wants to defend them. You use the legal tools that you can to defend them. There are a few that might come back and bite you someday, like the 10th Amendment. I mean, you have to think them through a little bit, but I think you use every legal tool that you have to preserve the policy outcome that you want. And I understand that, and I've helped groups use those kinds of arguments. I think that because so many of them are difficult in courts, I've also, and because it just fits with my kind of worldview, I do think that as much as there's a power base in cities that is a good place to start from with a lot of these progressive reforms, I don't think that we should just limit it to cities. It's not clear to me why there might not be a broader investment in paid sick leave and parental leave policies and minimum wage policies that are different at the state level. I know that there are different kinds of considerations, if you're not in a growing metropolitan area, that you have to take into consideration. But I think there are you can start to build these statewide coalitions, and I think it's really important that progressive groups do that. I also have, just in terms of some of the pragmatic approach, I found myself, and I hesitate to say this around Adam, but maybe, on the gun stuff, actually moving a little bit from my initial position. I mean, I feel very strongly about gun control on a personal level, but I found myself willing to accept the idea that there could be different policies for cities and there might be for rural areas. And it came out of the idea that the urgency for me around gun control is because I've always lived in a dense, city or a metropolitan area that frames my whole outlook on guns. And if I had grown up in a very different kind of environment, I might feel very differently about what's at stake. I mean, I'm very skeptical of the rhetoric around guns and NRA and all of that. So I'm not saying this naively, but I do understand that my own view of what is a metropolis where I live, my own experiences with crime, they influence on who I think should have guns and who I don't, influences how I see the issue. And if you grew up in a different area and the police are not close by and, things like that, you might feel differently, or if you hunted, And so, so I think that I have more tolerance for variation than I did before.
I would go back to what Adam pointed out about the animating values that are behind the preemption. I definitely am not married to the idea that non-discrimination ordinances should be at the local level. I mean, we at Equality North Carolina would love it if we could have a statewide non-discrimination law, but we have a supermajority in our legislature that has made clear that they are not going to let that happen. There's a bill that went through the last session that's still sitting in the Rules Committee. It would be a different story if the state had come in and said, like they did around restrooms, the actual language of the restroom preemption in the HB2 substitute is that cities, or really any political subdivisions cannot regulate restrooms except in accordance with an act of the General Assembly. So if the General Assembly wanted to waltz in and say, we want everyone to be able to access restrooms in accordance with their gender identity, there would be a round of applause from Equality North Carolina. But that is not at all. They haven't passed any restroom legislation. And in fact, the next legislative day after they signed this compromise, they introduced a bill that would enhance penalties for, bathroom trespass in North Carolina, which clearly indicates that they don't plan to give any additional rights. What they are doing is taking rights away. And I think the LGBTQ movement has really found that local ordinances are an effective way to respond to protecting LGBTQ people when states won't step in and when the federal government won't step in. So there's literally hundreds of cities across the United States who have successfully enacted non-discrimination ordinances, and chaos has not ensued. But we would, again, I think we're very pragmatic about it, and would anyone who wants to give greater protection to people's rights, I think we would welcome that. It's setting a minimum floor where we're not taking them away is where the problem with preemption comes in.
I want to sort of talking about that minimum floor of protection. I want to build off that a little bit in the gun context. And first say, Alati, you should always feel free to speak your mind about guns around me, particularly in cases like this where I think we agree. But I think that
everything I know I learned from that.
I think your point is well taken. I think it's absolutely appropriate for there to be variation in gun laws in different communities depending on their characteristics and their density and other things. And I think that we both live in New York City. I live in New York City, and I think the laws that make sense, the regulations, the way that guns are allowed to be used in a very densely populated urban area like New York City, probably for reasons that are common sense that we don't need to dwell on, are probably going to be different than the types of laws that would be appropriate all the way upstate in very sparsely populated rural communities where there may be fewer law enforcement. There may be a heightened need for self-defense to allow people to carry guns in public in a different way than they do on the subway at 8:30 in the morning. And so I think the notion of sort of localism, the notion of variation from rural to urban and on other dimensions is totally appropriate. I think the reason some of these preemption laws in the gun space have been so difficult is because I think it would be as inappropriate for New York City to say, we're going to set the rules for rural communities upstate as it would be for those rural communities upstate to say, the rules that make sense here, I have to take those with me when I'm on the subway, and I can do whatever I can back home. I think it's inappropriate for either type of community to make the rules for the other type of community. What we've seen on these gun cases, and this gets back to, I think, the intersection with some of the gerrymandering and some of the redistricting issues that we've seen, is that pretty much across the board, what we've seen is preemption laws adopted by legislatures that are overrepresenting those rural communities and underrepresenting those urban communities. So it is not the case that we have seen preemption functioning such that sort of cities like New York are making the rules for other communities. It's more a dynamic of legislators that are overrepresenting those rural communities are saying, one size fits all, and it's our size that fits for you. And so I think because so much gun violence, at least in terms of homicide and assault, leaving suicide aside, because so much of that happens in urban communities, to the extent that laws are being set at the state level that disfavor those urban communities, the preemption laws become a problem. So I think that's the perspective that we in the gun violence prevention space bring to this issue.
So I'm watching the time. We have about 25 minutes left. I really want to get to audience Q&A because I just want to say one thing before I hand it over, and again, I would encourage people who have questions to come up to the microphone. Another really interesting theme, and we'll see if it comes out in the Q&A, that strikes me is the interplay between federal law, federal dimensions, and localism. And I think that for many advocates who are used to advancing questions using a federal toolkit. One of the interesting things about the kind of current wave of state-local conflicts is it's, I think, pushing people to become much more expert about home rule, about a set of state constitutional claims, that for those of us who study local government have been pretty obscure and sort of sitting in the backwater, but are really actually coming to the fore. And we can have an interesting conversation about a case like Hunter and sort of whether that reflects actually home rule and constitutional home rule in the more than 40 states that have constitutional home rule. But there's been an interesting dynamic as these cases have played out about shifting the ground of advocacy. And as important as the federal claims are, they're interacting with and also running parallel to a very interesting set of state-based, state constitutional claims. And obviously in many of these cases, in the Florida firearms case is a good example, they're both playing out. So with that sort of aside and reflection, let's get some questions from the audience and see if we can have a larger conversation. Thank you. And please identify yourself when you ask your question.
Yeah, my name is Malvina Nathanson. I'm from New York City. Don't like guns either. But I didn't hear an answer or response to what Mr. Russell said. I think I would tend to agree that all other things being equal, it might make some sense for certain rules to apply to localities, to rural localities, and certain to cities, and all that's very nice. And maybe in other cases, you do it that way because it's better than nothing if the state hasn't passed a law. But once you've set up that kind of a structure, when the state comes in and says, we're preempting you, Mr. Russell says, that's the end of the ball game. Is it, or is he overstating his case?
Well, I don't think it's the end of the ball game. Read the American Constitution Society brief on ways in which you can legally challenge preemption. That some of us on this panel, Nestor, myself, and Richard Berfault, Paul Diller, and Rich Schrager, wrote, which has some of the legal tools that you can use. I mean, they could be home rule, and there are equal protection tools. They're the First Amendment due process tools, and I think especially with regard, and there's more them even after that written. Recently there's I think Stanford had something on preemption. Richard Schrager has written about assault on cities that talks about some of the legal strategies, but mostly some of the historical and political strategies. So there are legal tools out there, and I think some of them, it's just that we're putting them forward and they're being tested in the courts, and we'll see. I don't think it's absolute at all. And especially to me around civil rights areas, I do think that states have overreached. And the second area I think they really have overreached is what Adam was talking about with regard to the punitive preemption. And I think even aside from the legal challenges, I just want to make it really clear that I actually think that the building on what Adam said, there is a severe democratic distortion going on with regard to the punitive preemption. I mean, it's almost like all the little doctrines around, they're not little, but First Amendment due process don't even capture the sort of wrong that goes on when the NRA feels like it can just walk into the state legislature's offices and get a kind of a bill that has no precedent in, or legislation has no precedent in American democracy to do that to local officials. Okay, so I mean, it's such an overreach of the kind that suggests that there's something going on that's not even well captured by those legal doctrines. But the short answer to your question is yes, there are legal tools. And then just the last comment is that one of the things, even as we were writing this brief, the ACS brief, that really struck a lot of us was just that I think there's a democratic challenge right now, or there's a constitutional challenge in the fact that cities do not have constitutional status under the U.S. Constitution. I mean, they're not accounted for. And yet there's such a way of arranging our society and the way our society is actually structured today, and where economic power lies, where a lot of social cultural power lies. And yet it's very fraught because of the perception that cities may in fact be too dominant, even though they're not actually dominant at the state legislative level. So there's something going on at this moment that I think we have to attend to that's broader than the individual doctrines. I'm just not sure how we're going to resolve those issues. It's not clear to me yet.
Can I chime in? That's true. Well, as I think she just said, I mean, the punitive stuff I agree with completely. That's ridiculous. But the preemption, you're just not going to find case law going against state preemption in regard, as long as it was done correctly. But, I mean, even, we touched on home rule just a minute ago. Even home rule is a creation of the state. And even Judge Cooley in that ruling in particular even acknowledged that fact, that while cities can be established and to have the ability to do home rule, it does not exempt them from preemption.
Yeah. I mean, I would just look at, I think certainly as a matter of federal constitutional law, Hunter still is the dominant view. There's a view of local government, cities, towns, counties as creatures of the state. But I will just say, and again, you know, we can respectfully disagree, that there are doctrines in state constitutional law that recognize, in some circumstances, protections when states overreach. So, for example, there's case law that deals with the ability to target local governments. So, there are recent cases in Florida, in Ohio, and other states that say that legislation has to be general. And when legislatures pick on and target individual cities, that has been struck down. There are also procedural requirements. So it could be that you can preempt, but you can't sneak a preemption bill into an omnibus bill that deals with puppy mills or something entirely unrelated. And we have these 19th century constitutional provisions about single subject rules, which frankly just had no traction for decades and decades and decades. And in the last 4 or 5 years, you've seen a series of cases where, you know, the Missouri Supreme Court strikes down a legislation on minimum wage because it was snuck into a larger bill. So I think that the landscape, it is certainly true that in direct head-to-head conflicts, cities tend to lose. But I don't think it's as simple as sort of Hunter is the law of the state, because I think state constitutional law actually gives some protection and does give some recognition to democratic polities at the local level, even if it's not as strong as it could be.
And National League of Cities has also done some work in that area.
Thank you to the panel. My name is Matthew. I think one of the unifying themes I think is coming out of the panel is that the preemption is a tool. You can use it to sort of promote the policy values that you have. I think what's troubling me a little bit is, in some ways, the history of the civil rights movement focused on policies in the South and used, you know, federal preemption to promote progressive views of the law, be it the Civil Rights Act, be it the Voting Rights Act. So how do you incorporate that tension, or is there a tension, or is it simply that was the tool that was used then and this is a new tool that sort of we're employing today?
Well, I mean, I'd be interested to hear what other people think about it. I mean, I don't think it's a tension, but that's because I think that the congressional expression in the Civil Rights Act is enforcing notions of equal protection, under-enforced before that, right? And so I think that equality and that kind of, and certain dignity inherent in citizenship, or not even in personhood, in the United States. And so, I mean, to be clear, the civil rights statutes don't preempt things that go further, right? But they're establishing a floor, and it's, you know, it's not the most robust floor. I mean, there are categories that are left out, and there are approaches that could have been taken that weren't taken, right? So I don't see it as a tension. I think but it does return us to that original issue of, are we really concerned about levels of government per se? They're really, I think that, I don't know if I had to send everything through that filter that I would have the exact same argument in, but I think that with regard to things that have to do with civil rights, equality rights, you're expressing a constitutional value, and some people think an inherent value that's a human rights value that should be there at the national level. So, I mean, I'm interested in what other people have to say on it.
I think that's exactly right, and that was the basis of the ACLU's lawsuit against HB2, and they updated it for HB 142, equal protection.
Yeah, I also agree. I mean, I don't think I would describe it as tension to the extent that we set sort of the floors at higher levels of government, and then if at lower, smaller levels of government we want to go beyond that. If you accept the notion of setting a floor to protect something like dignity or to protect equality, equal opportunity, than the notion that, you know, let's set the floor at a higher level of government, but in particular communities that are smaller than national in scope, we can elevate and have heightened standards. To me, some of that tension drops away. And, you know, I often talk, bringing it back to guns, because that's what I do, I often talk about these principles as they relate to guns by analogizing to pollution, right? You know, pollution is something that, air pollution, at a certain level, because air pollution blows around across state lines, it makes sense to set the floors at the highest levels. You know, if I set in my state a very high control on air pollution, but the state upwind for me, I think I've got the upwind downwind thing right. The state upwind has no controls at all. My law restricting air pollution isn't going to do me that much good, right? Because the pollution's just going to blow downwind, I think is the direction it blows, into my state, right? So there are certain things that we need to set the basic standards, the basic floors at a higher level of government, at a federal level in the case of that analogy. You know, I analogize guns to air pollution in the sense that guns, like pollution, travel very easily across state lines. So certain floors that we want to set in terms of policy, in terms of saying somebody who is, you know, making threats to commit a mass shooting should be disqualified from buying a gun. Certain standards like that, I think, are appropriate to enact at a federal level, or as between states and localities, at state level, at the higher level of government. But that doesn't mean that other policies, like, you know, who should be, like, you know, whether you should be able to carry a gun in your car in a rural area versus an urban area, that some of those other questions could be resolved at a lower level. And in that case, you know, generally with heightened standards beyond the floor set in a more crowded urban area. So, you know, there certainly is a tension that, you know, people who resist limits on local control in a particular area, like the ability to regulate guns, might be perfectly fine saying, but we should have federal civil rights laws because we want to set a higher floor. Yes, there is a tension in the sense that they're okay with federal rules in one context, but prefer local rules in another. But if, again, you get back to like what the animating principle of what they're trying to accomplish is, I think that tension goes away a bit.
Thank you.
Good afternoon. My name is David Lillehog. I'm a state court judge, and I'm pleased to see that ACS is paying some attention to state law and local law issues. I have a question primarily for the law professors. We've got well-established federal law on preemption, express preemption, direct conflict preemption, and field preemption. I want to ask about field preemption, which is an argument being made in some challenges primarily to economic ordinances. Do you think the framework for field preemption vis-a-vis the state versus local level should be pretty much the same as the federal versus state level? What kind of framework should we be adopting for field preemption in analyzing whether local ordinances are preempted by state law?
Do you want to take that?
Sure, I'll take a first crack at it. I mean, I'll just say as a slightly abstract matter, I think it's important, I think there's an instinct to look to federal law and the law of federal-state relations and analogize it to state-local. And as you know, there are many, many differences. And so I think we have to be cautious about wholesale adoption of principles that you derive from federal preemption law into state law. So I think there are some advantages to having 50 places to try different laws. I think that the arguments for a kind of withdrawal of authority, and again, it depends on what the state constitution says about home rule. I think it's very different if you're in a Dillon's rule state, where it's just all legislative delegation, and there it's very clear as a matter of state constitutional law that the state legislature has much, much more authority to structure local power, right? But if the basic bargain that has driven home rule in most states, which is you're going to get a tremendous amount of initiative authority, and then states can act to override that. I mean, that's the basic, Faustian or otherwise, however you want to think about it, that's the basic bargain that has driven home rule reform for the last 50 years. I think if you think about that basic bargain, then merely saying that the state hasn't acted and the sort of there's an implication of occupying the field seems to run a little bit in tension with that. Because the idea of constitutional home rule is that at least local government should be able to act in the first instance. And then if they conflict with an overriding and important state interest, the state can then step in and explicitly preempt. I think that the basic logic of home rule in the states that have it suggests that we should be a little cautious about kind of an implied or a field kind of preemption. But that's, I think that states have taken, as you know, different approaches to that. But that's my view. I don't know if anyone wants. I mean, this is really way inside baseball, state and local government stuff. Why don't we take another question? Sorry.
My name is Natasha, and I'm a law student at Columbia Law School. So I'm pleased to see a Columbia professor up here. My question is, in law school, we focus a lot on litigation, and I think this panel has focused a lot on litigation as well. Are there lessons to be learned from the rights playbook in terms of winning at the state level, particularly when we look at upcoming elections, which have a lot of progressive minority candidates, a lot of women, a lot of people of color coming into state office? Kind of what should we be setting up in terms of infrastructure now to maybe accomplish some of the goals we want to? Thank you.
So as a libertarian, I'm going to answer that for you. I think one of the ideas that hasn't been floated here, but I think has some merit to look at, is this idea of autonomous cities. And how do we look at that within the structure of the state? I think New York City is a great example of what would something like that inserted into the Constitution look like. And I don't think we've had enough of those kinds of discussions in a productive manner. I don't think we'll ever get to city-state. I don't think D.C. will ever be a state. I could be wrong, but I don't think we'll ever get the city-state process, but this idea of autonomous cities within state constitutions, I think, has some intriguing things to look at. And I don't know how that helps the progressives, but it's just, just something I wanted to throw in there because it did come up in the last conversation.
Great.
Yeah. I guess my responses are more prosaic, I guess. Oh, that's an interesting idea. But just in some ways, I think people are learning that lesson now. I think you see a lot more engagement at the state and local level, even in states that are so-called blue states. I think you see it, but certainly in the red states focused at the state legislative level, more people running for office. And I think that the infrastructure, unfortunately, in our climate has to depend, well, fortunately on people, but also on money. And so I don't know if we have the resources to match that, way behind a lot of industry-fueled groups and conservative groups on that. But I think that's the infrastructure. And there's so many reasons why, to focus at the state level, including state preemption, but also just, redistricting. And so I think that people are beginning to learn that lesson now and are engaging at that level. There's just a lot more to be done.
I do think there are some pieces of the playbook of the extreme right that the progressive movement just will not take on. And I think that the analogy to the extreme gerrymandering that we've been talking about is one of those pieces. I think what we've seen in North Carolina is not that, like, the sort of upswell from the grassroots against gerrymandering in North Carolina has largely not played out with, like, well, once the Democrats are in power, we're going to make sure that we gerrymander so only Democrats are in power. It's been much more having a conversation about nonpartisan, independent redistricting commissions in a way to try to prevent either party from being able to take advantage in that way.
Hi, my name is Michael Lambert. I'm a law student from the University of Mississippi. I was really pleased to hear y'all talk a little bit in terms of the gun control arena about these variations. I'm very much someone, if you can't tell, did not come from New York City or another metropolitan area.
You're always welcome.
Yeah. So it's been a little bit difficult for me in the gun control debate to reconcile what I truly feel on a policy level versus what I personally experienced. But when I was hearing y'all talk about these variation considerations for guns, it seemed like, talking about that kind of rural versus city divide and kind of the practical elements of safety and law enforcement. And when we're looking at these variations in preemption, how exactly do we propose to identify the operative facts that determine, I guess, the minimum stage that we want to govern at? With something like gun control, it seems kind of intuitive. We're talking about guns, we're talking about, you know, self-help versus police. What about something like sexual orientation and gender identity? You know, in many communities that are very religiously segregated, maybe someone could come forward with the argument and say, well, most of our community is faith-based, so in order to, for a variation for us should be made because we have a mostly faith-based community. Does that make sense? Okay.
I think that part of the conversation that we're having nationally right now is trying to come to terms with the idea that sexual orientation and gender identity are part of civil rights, and they're not something that is sort of okay for some people and then okay for other people to object to. And part of what my organization is invested in is trying to get that conversation to be happening on a broader level. So in a way that we couldn't say, you know, well, essentially, as long as everybody's okay with separate but equal, no harm, no foul. It just isn't. It isn't analogous in the same way, I don't think.
I think we have time for one more question, and then I would just say that the next plenary panel, which is called Me Too, Us Too, Can Lawyers Take the Lead, begins at 4:15, so you have a little bit of a break, but I encourage you to move to the plenary relatively quickly. But with that last public service announcement, let's take our last question.
Hey, I'm Alex Robertson. I'm from Baltimore, Maryland. I have a question about, I'm not sure if anybody's familiar with this case, but it's the case of Jackson, Mississippi and Chokwe Lumumba. And there was some mention of like animating principles behind some of these preemption laws. And you know, I heard a recent interview with Mayor Lumumba. It was really part of this, you know, left-wing movement, the Action Jackson movement, that's taking control in Jackson. And there's been a lot of changes in terms of actually removing the authority of Jackson to really control itself as a municipality. And I think there's some litigation. I don't know all the facts, but I was wondering if any of you are familiar with that case and could comment on it.
I'm not familiar with that case, but I'm eager to find out more. I mean, I do think the precedent in Birmingham with regard to using some of this voting rights law, or because of early kinds of actions that were taken in various southern states to limit the authority of African American municipal leaders once they came into power. I mean, there was a history of that. I don't want to just confine it to the American South, but a lot of the cases came up through, you know, in the South. And so this sounds, just from the contours that you gave, a kind of similar issue happening. I mean, there's a precedent of this in American governance.
Well, join me in thanking our panel.